If Karen Read is ultimately convicted in this case, all of the blame, in my view, can be placed entirely at her feet. If you are going to speak this freely to the media like this, it is going to burn you. Lawyers for both sides of a highly anticipated retrial in Massachusetts waste no time in bringing the fireworks. Plus, the so-called doomsday mom is quickly convicted by an Arizona jury for conspiracy and murder charges of her fourth husband, and a Florida man accused of the systematic assault and murder of his girlfriend's 13-year-old daughter argues to have key evidence against him thrown out. All this and more this week on Courtroom Confidential. As one high-profile trial ends, another begins. A lot for us to discuss this week. We are recording this episode on Friday, April 25th, 2025, and this is your Courtroom Confidential weekly roundup. Let's jump in. The retrial of Massachusetts woman Karen Read began Tuesday, 9 months after a jury failed to reach a verdict in her first trial for the alleged murder of Boston police officer John O'Keefe. Read is charged with second-degree murder, manslaughter while operating a vehicle under the influence of alcohol, and leaving the scene of an accident causing death. In opening statement, Special Prosecutor Hank Brennan told jurors that Read deliberately struck O'Keefe with her Lexus SUV in a drunken rage and left him dying in the snow outside another officer's home at 34 Fairview Road in January of 2022. Brennan ended by playing a clip from an October 24th Dateline interview with Read.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
Defense attorney Alan Jackson countered that, in fact, no collision ever occurred, and instead the investigation was riddled with errors, bias, and incompetence led by disgraced lead investigator Trooper Michael Proctor. The prosecution kicked off their case with firefighter and paramedic Timothy Nuttall testifying that as he was attending to O'Keefe, Read said, quote, "I hit him, I hit him, I hit him." Under cross-examination, he admitted he'd previously testified to her saying it only twice, not 3 times. Next, Carrie Roberts, a longtime friend of O'Keefe's, testified about going out with Read along with another then friend, Jennifer McCabe, to search for him. Her testimony continued into day 2, where Roberts testified about accompanying Read to O'Keefe's home to look for him. She said that when they arrived, Read pointed out her broken taillight. Roberts recounted how Read later spotted what looked like a dark blob outside 34 Fairview Road. Roberts said she didn't recognize O'Keefe until snow was brushed from his face. On cross, Jackson suggested Roberts' memory had been shaped by McCabe, now a close friend. He pointed out Roberts previously told a grand jury she heard Read tell McCabe to Google hypothermia. Roberts ultimately admitted she hadn't actually heard Read say that, but was instead told that by McCabe. Prosecutor Hank Brennan has also sought to make great use of statements Read has made in prior media interviews. In one clip, Read appears to mock Peggy O'Keefe, John's mother.
And his mother leans over the kitchen island and says to me, "I think it looks like he got hit by a car. It looks like he got hit by a car."
In another clip, Read discusses her drinking that night. Read said she ordered what she considered to be between 3 and 4 drinks, adding additional shots of vodka to each, saying that she felt buzzed and was, quote, fuzzier than I would have been if I had tea. Finally, Trooper Nicholas Garino to return to the stand to read text messages between Read and O'Keefe in the days and hours before his death. The texts revealed a strained relationship, tension around parenting, and plans to see one another. Quote, "Tell me if you're interested in someone else. Can't think of any other reason you are like this," Read wrote at one point. O'Keefe replied, "Things haven't been great between us for a while. Ever consider that?" Judge Cannoni informed the jury they'd be out of the courtroom Friday, April 25th, visiting sites related to the case. What's happening here? I'm going to shoot very straight with you folks. If Karen Read is ultimately convicted in this case, all of the blame, in my view, can be placed entirely at her feet. I don't care how good your attorneys are. And she's got very good attorneys, by the way, some of the best attorneys in the game right now. But if you are going to speak this freely to the media like this, it is going to burn you. We've all heard the Miranda warnings. You have the right to remain silent. Anything you say can and will be used against you. That is what's happening here. It doesn't have to be admissions, folks. It doesn't have to be confessions. It can just be anything that the prosecution can use to move the needle forward. And I know a lot of people are saying, well, isn't this just portraying her in a bad light? And what does this really have to do with what took place that evening? It's her own statements. It's her own statements. And there's really very little that the defense can do to keep this out. Just listen to some of these statements and try to imagine what the jury is thinking, hearing them for the first time. I know many of you watching and listening to this have been following this case and perhaps the first case and all the media coverage attendant to it. But these jurors, hopefully, have not. So for the first time, they're hearing some of these things. For the first time, they're maybe even realizing that she's ever even given these interviews. These are not courtroom step interviews, by the way. These are sit down, lights and cameras, hair and makeup interviews. First, with Dateline that aired on October 18th of 2024. This is a quote. I mean, I didn't think I hit him. But could I have clipped him? Could I have tapped him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see. Or could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again? Here's another from an ID docuseries that she took part in. Nearly unfettered access to this woman and her defense team during the first trial. This aired on June 15th, 2024. Quote, but I also wondered, did I say that I hit him? Or was it told to me that I said I hit him? And I knew I never could have said that. So the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it? Are these confessions of murder? No. Could they lead to her conviction for vehicular manslaughter? Absolutely. Listen, I get it. I get what people are saying, that these can be explained, that these are taken out of context, that when you listen to the entire interview, they don't have the same impact as when you're nitpicking and cherry picking specific quotes. I get that. Sure. But if the defense is in the position of having to add context to statements like this, they are already in the red. You do not want to be digging yourself out of the kind of holes that were created from your own missteps. And in my view, these are absolutely missteps. I know that she has said, well, I talk to the media because it's my opportunity to tell my side of the story. Well, you're telling your side of the story, and your side of the story is getting told in court, and you're not able to explain it. And your defense attorneys are not able to get up and redirect whatever missteps may have taken place in those statements. Now all we have are these statements. Does this change anything about the investigation? Absolutely not. Is the investigation still sloppy? Yes. Does it appear to be a rush to judgment? Sure. All of those things. But I'll tell you this, no matter how you feel about the police investigation, sloppy, rush to judgment, mismanaged, bad cops, you know what gets jurors past all of that? Stuff like this. Words from the defendant's own mouth. Sit down interviews with people where she's freely talking about what took place. And those include some of the statements that I just read to you. Things like, perhaps I did hit him. Maybe I clipped him. That's all the prosecution needs out of this. They don't need her to say, I meant to hit him and I'm glad that I did it. They just need some sort of admission that she was involved in that collision, because, by the way, her entire defense as laid out in opening statements is that there was no collision whatsoever. All the great sins of law enforcement can be forgiven if the jury believes the defendant is essentially telling us that she was involved. But what do you guys think? Are these media interviews as important as I think that they are, or is this something that jurors may soon forget? Please let us know in the comments. Lori Vallow Daybell, already serving life sentences in Idaho for the killings of her two youngest children and a romantic rival, was convicted Tuesday in Arizona for conspiring to murder her former husband. Jurors deliberated for about 3 hours before finding Vallow Daybell guilty in the 2019 shooting death of Charles Vallow, who was killed at her home in Chandler. Prosecutors said she was assisted in the murder by her brother, Alex Cox, who was motivated by the prospect of collecting life insurance money and marrying Chad Daybell, her religious leader who wrote several novels about prophecies and the end of the world. Vallow Daybell now faces another possible life sentence, though she won't be sentenced in Arizona until after standing trial for an additional alleged attempted murder conspiracy. Chad Daybell is also serving life for the murders of Vallow Daybell's children, 7-year-old Joshua J.J. Vallow and 16-year-old Tylee Ryan, as well as his first wife, Tammy Daybell. Vallow Daybell, who represented herself at trial, sat mostly still as the verdict was read, occasionally glancing at the jury. Juror Victoria Lewis later told reporters Vallow Daybell's decision to represent herself didn't help her case. Quote, many days she was just smiling and laughing and didn't seem to take anything very seriously, Lewis told reporters. Vallow Daybell told the jury that Charles Vallow had chased her with a bat inside their home, and her brother shot him in self-defense as she left the house. She told jurors his death was a tragedy, not a crime. Alex Cox died 5 months later from what medical examiners said was a blood clot in his lungs. Vallow's siblings, Kay Woodcock and Jerry Vallow, told reporters outside court that they are grateful for the jury's decision. Quote, we gotcha. And you're not the smartest person in the room, Woodcock said, when asked if she has a message for Vallow Daybell. Quote, everybody's going to forget about you. Vallow Daybell is scheduled to go on trial again in early June, this time accused of conspiring to kill Brandon Boudreaux, the ex-husband of her niece. Boudreaux survived the attempt. Well, what's happening here? The results of this case really should not be shocking to anyone. If you were watching this, it was very obvious what direction this was all heading. Yet, while at one point I actually thought she was going to present a real defense in this case, a defense, by the way, that is not without valid arguments, instead, this entire thing devolved into her own personal agenda about gossip and jealousies. And so while I'm not shocked by the verdict, I am shocked by one thing. I'm shocked that she never testified. This person, a narcissist, a cult extremist and zealot, a person who decided to represent herself because she believes no one else could do a better job than her, that person decided not to testify. And that does shock me. One last thing on this. Many people have asked, was this all worth it? Why did we go through all of this? If she's already serving life sentences in Idaho, what's the point in doing all of this? Was this a waste of time, a waste of resources? And I think absolutely not. And you see why. You see why from the victims' family members. This is about something bigger. It's about justice, as all cases are. Justice for the victims, settling accounts, making sure that no one gets a pass, and quite frankly, a little bit of insurance, because you never know what will happen on appeal in some of these other cases. But what do you guys think? Do you think there's any way this trial could have ended any other way? Please let us know in the comments. A Florida man charged with the sexual assault and murder of a teen girl made a rare court appearance Wednesday, testifying during a motions hearing as he seeks to have key evidence in the case against him tossed out. Stephan Sterns is charged with murdering 13-year-old Madeline Soto, his girlfriend's daughter, just days after her birthday. He also faces 60 charges that he sexually abused Soto in the years before she was killed. Soto was reported missing on February 26, 2024, after her mother discovered she never made it to school. Her body was found on March 1st. While police were still searching for Soto, they interviewed Sterns on February 26th and 27th. During one interview, a detective began looking through Sterns' phone and allegedly found photos showing Soto being sexually abused. At Wednesday's hearing, Sterns' defense argued the detectives lacked a warrant and asked the court to throw out all evidence found on the phone. Sterns testified that he believed detectives, quote, were just going to check my Google Maps. That was it. That was all I agreed to. Prosecutors countered that Sterns gave verbal consent multiple times at the scene and was standing close enough to see what detectives were viewing. Judge Keith Karsten told the court he would review the arguments and issue a written ruling at a later date. What's happening here? This is probably one of the most disturbing cases that we have discussed on this channel, and it's rare that you come across something this depraved. And it's moments like this that demonstrate why in these very serious cases with tremendous consequences, police work should be done without reproach. This is no time for mistakes. This is no time for moving with haste. But I think it also demonstrates how difficult it can be for law enforcement in a very fluid and fast-moving investigation to make the right decision. Think about this, okay? Police are interviewing a man that they believe may be involved in the brutal murder of a 13-year-old girl. They ask to see his phone. They're looking through his phone, and when viewing that phone, they see seriously incriminating evidence. What do? Now, some may say that you need to stop immediately. Get either written consent, verbal recorded consent, maybe even go out and get a warrant. But what if you do, and in that time, he destroys everything? What if you do if you are not granted that warrant for whatever probable cause issues? So you don't risk it. You decide, I need to make sure this evidence is seized here and now. And though you don't want to risk him destroying it, what do you risk? Well, you risk this situation. Perhaps a judge finds that you acted without consent, without a warrant, and without probable cause, and it all gets thrown out. And along with that evidence, perhaps your case, by the way, because a lot of this case hinges on that. A lot of this case came out of that. Talking about fruit of the poisonous tree type situations, if it all leads back to this first discovery. Did they make the right call at that time? I think probably yes. But now this case rests in the hands of a judge. And I am not sitting here trying to tell you they acted wrong or they acted right or the judge should rule this way or that. This is a close case. And I think the judge will probably lean towards the idea that law enforcement is saying he knew what we were doing. He was giving us consent. I have other officers to testify to the same. But this is one of those situations where cases can completely fall apart, and it's all because of decisions made by law enforcement. And again, I'm not trying to say they acted wrongly or illegally here. I'm just saying this is for us all to appreciate how difficult these situations can be. It's not just like something you're reading out of a textbook. It's fluid situations, and it's thinking on your feet, and it's making incredibly, sometimes very consequential decisions in a moment. But what do you guys think? Do you think the police made the right call by searching then and there without some sort of written consent or warrant? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask one very small favor from you, and that is if you haven't already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way that we can do that is through your support. And please don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, within weeks of trial set to begin, the lawyers for a Florida matriarch alleged to have orchestrated the murder of a law professor are asking for a delay. Donna Adelson is accused of masterminding the 2014 murder for hire of her former son-in-law, Florida State University law professor Dan Markell. Trial is currently set to begin June 3rd. The motion to delay comes a week after Adelson's defense team sought to disqualify the current judge from presiding over the trial. The motion was filed under seal, leaving it unclear as to why the request was made. Judge Stephen Everett denied the motion without comment. Court records show that Adelson is expected to appear in court via Zoom for the motion to continue on Wednesday, April 30th. Adelson's son, Charlie, is currently serving a life sentence for his role in the plot. 3 others, Sigfredo Garcia, Luis Rivera, and Catherine McBanois, are also serving time in connection to Markel's murder. A Southern California judge was convicted Tuesday of second-degree murder for fatally shooting his wife during an argument in their home. Orange County Superior Court Judge Jeffrey Ferguson admitted on the stand to shooting his wife, Cheryl, but claimed it was accidental. Jurors disagreed, convicting him after just 1 day of deliberations. After the verdict was read, Ferguson hugged his son before being handcuffed and taken into custody. Ferguson's attorney, Cameron Talley, said the defense plans to appeal. "I respect the jury's verdict," Talley said. "At the same time, we all know that juries don't always get it right. I still believe in Jeff." This conviction comes after a previous jury deadlocked in March, resulting in a mistrial. Prosecutors said Ferguson had been drinking before he made a gun-like hand gesture toward his wife of 27 years during an argument over family finances on August 3, 2023. Later at home, while watching TV with their adult son, Cheryl challenged Ferguson to point a real gun at her. Ferguson did, and fired, prosecutors argued. Ferguson faces up to 40 years to life in prison. Sentencing will be on June 13th. A judge on Thursday denied a motion to remove the death penalty as a sentencing option in the trial of the man accused of fatally stabbing 4 University of Idaho students in 2022. Bryan Kohberger's attorneys argued that his diagnosis of autism spectrum disorder should disqualify him from capital punishment, calling it dehumanizing. However, Judge Stephen Hippler rejected the claim, writing, quote, "No court has ever found ASD to be a categorically death disqualifying diagnosis." He agreed with the prosecutors that autism does not meet the legal threshold for intellectual disability exemptions and noted there is no national consensus on the issue. Kohberger is charged with killing Madison Mogen, Kaylee Gonzalez, Xana Kernodle, and Ethan Chapin at an off-campus home in Moscow, Idaho on November 13th, 2022. In a separate ruling, Hippler also allowed most of a 911 call from surviving roommates and their text messages to be admitted at trial, except for 2 redacted portions of the call. Quote, "Some of the hearsay statements on the 911 call do not qualify under the exceptions cited by the state and therefore must be redacted," Hippler wrote. However, the balance of the 911 call, as well as the texts and conversations noted herein, are likely admissible provided that the requisite foundation is laid at trial. Kohberger faces 4 counts of first-degree murder and 1 count of burglary. His next court appearance is set for May 15th, with trial scheduled to begin August 11th. The second trial for a Hollywood mogul accused of sexual assault becoming the figurehead of the Me Too movement began in New York on Wednesday. Harvey Weinstein's retrial kicked off with prosecutors giving a new jury a fresh look at familiar sexual assault allegations, plus a newly added claim from a former model. For the first time, Kea Sokola was publicly named in court. Prosecutors say Weinstein forced oral sex on her in 2006, and in a separate civil suit, she accused him of groping her when she was just 16 years old. Like the 2 other women in the case, Sokola described a complicated series of encounters and reactions, alleging abuse, yet remaining in contact with Weinstein in hopes of an acting career. Why did the defendant hold this level of power and control in the eyes of these 3 women? It's because Harvey Weinstein defined the field, prosecutor Shannon Lucy told jurors in opening statements. He knew how tempting promises of success were. He produced, he choreographed, he therefore directed their ultimate silence for years. Weinstein, now 73 and in a wheelchair, has, through his attorney Arthur Aidala, dismissed the allegations as transactional, telling the mostly female jury, quote, "The casting couch is not a crime scene," and calling the case a preview of a movie that falls flat on its face. The retrial comes after New York's highest court overturned Weinstein's 2020 conviction, ruling that the original trial was unfair due to prejudicial testimony about allegations separate from the charges. In addition to the charge related to Sokola, Weinstein is being retried for allegedly forcibly performing oral sex on then production assistant Miriam Haley in 2006, and a 3rd-degree rape charge for allegedly assaulting then aspiring actress Jessica Mann in 2013. The man who killed 7 people and wounded nearly 50 others during a 4th of July parade in Highland Park, Illinois, will spend the rest of his life in prison. On Thursday, a judge sentenced Robert Bobby Crimo III to 7 consecutive life sentences, calling him irrevocably depraved and beyond any rehabilitation. Crimo had pled guilty in March to 69 counts of murder and attempted murder, declined to attend his sentencing or speak in court. His unexpected plea brought an abrupt end to what was expected to be a lengthy trial. During the 2-day hearing, victims of the attack gave powerful testimony about the shooting's aftermath. Those killed in the July 4th, 2022 attack included Stephan Sterns, aged 88, Nicholas Toledo Zaragoza, 78, Eduardo Ovaldo, 69, Catherine Goldstein, 64, Jacqueline Sundheim, 63, and married couple Kevin and Irina McCarthy, ages 37 and 35. Illinois does not have capital punishment, making life without parole the harshest sentence Crimo could receive. The man investigators believe stalked and murdered a healthcare executive last year pled not guilty on Friday in a Manhattan federal court. Luigi Mangione is facing 4 federal charges: murder, using a weapon with a silencer, and 2 counts of stalking of United Healthcare CEO Brian Thompson. Prosecutors are seeking the death penalty. The judge has ordered all discovery to be produced by the prosecution within 30 days. This includes search warrants, social media, and information from the Pennsylvania prosecutors and Manhattan District Attorney. Mangione was arrested at a McDonald's in Pennsylvania several days after the murder. He faces 2 separate murder cases, one in state court and one in federal. Although it was previously agreed the state trial would proceed first, defense attorneys now want the federal case to go first, given the potential for the death penalty. The judge set the next conference for December, when she plans to schedule a trial date. Before we get to what's on the docket for next week, I wanted to thank you all for being a part of our growing Courtroom Confidential community. But I want to give a very special shout out to Fatima Elreda for their fantastic review on Apple Podcasts, and as well as to our CC crew members Future and Lake Life 67 for their support on YouTube. Keep them coming. We absolutely love hearing from you. And please tell us where you're from. We are thrilled by the growth of our Courtroom Confidential community. On the docket next week, San Antonio man Brad Simpson, who is charged in connection with his wife Suzanne's disappearance and death, is expected to appear in court on Tuesday, April 29th for a pretrial hearing. Suzanne was last seen outside her home fighting with Brad on October 6th of 2024. Her body has never been located. Courtney Clenny, the Miami OnlyFans model facing a second-degree murder charge in the 2022 stabbing death of her boyfriend Christian Obumseli, will be in court on Wednesday, April 30th for a motions hearing. Wealthy Miami Beach twins Oren and Alon Alexander, charged with rape and sexual assault in 3 separate cases, will be back in federal court on Wednesday, April 30th for a status hearing. And finally, please join us this Sunday for our special question and answer series, Sunday Fun Day. All are invited to leave us a voice message, and we hope that you do, at thecourtroomconfidential.com, which we will answer during tomorrow's live stream at 9 a.m. Pacific, noon Eastern. And that is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.